Good morning, Mr. Miles.
Good morning, Your Honors. My name is Harry Miles, and I represent the appellant in this matter, who remains confined to the Massachusetts Treatment Center despite the Commonwealth's failure to file a petition to commit him pursuant to Chapter 123A, Section 14.
I'm trying to figure out what the prejudice to your client's liberty interests here, due to the fact that the Commonwealth filed on the 59th day versus the petition on the 59th versus the 57th, where he can be held for 60 days. What's the prejudice to your client?
I disagree with part of the premise on which that question is formatted, if the Court will permit me to elucidate. In order to say that the government has the power to confine an individual for 60 days, one, I suggest, misreads the statute. The statute confronts the constitutional tension between a preemptive deprivation of personal liberty and the need to protect the public against acts which may be committed in the future. If you look at 13A, Section 13A, that permits the commitment and confinement of the individual to the treatment center for not more than 60 days. That's an inequality. It's not an equality. Since it is an inequality,
In other words, you can't be held beyond 60 days.
That's correct.
Absent a petition for trial.
That's correct. But you can be held for less than 60 days. If one were to set this up...
But if so let's you can take this case, though. What is the prejudice here?
The prejudice is the deprivation of liberty, 2 days' worth beyond the 14-day outer limit.
2 days' worth? In other words, if the petition wasn't filed within 14 days, he has to be released.
That's correct.
That's your position.
Absolutely.
Mr. Miles, why isn't this case governed by Gagnon, though?
Because Gagnon, Gillis, and Gross, the 3 Gs of commitment, essentially deal with situations in which the petitions are filed after the 60th day or never filed. And the parsing of the statute, which I urge upon the Court, is that the legislature, in order to resolve and compromise the tension between the deprivation of personal liberty and the protection of the public, essentially said that the Commonwealth must file within 14 days of the filing of the report. That's Section 14A. This Court has said that if you would also look at Section 13A, a bright line outer limit of 60 days also governs the filing of the petition. So if one were to symbolize this as an equation in which F stands for the filing of the petition, R stands for the filing of the report, you get an equation which says F is less than or equal to R plus 14, the 14 days. That single equation would allow the filing of a petition beyond the 60-day limit found in Section 13A, because it says nothing about outer boundaries. So the second statement is F is less than or equal to 60 days, which tells us that no matter when the reports are filed and trigger the Commonwealth's ability to file a petition, the maximum outer limit of confinement is 60 days.
There simply is no authority to hold someone after 60 days.
That's correct.
Zero. Zip.
That's correct.
So every day thereafter is a deprivation of liberty.
And every
And that's
day,
what we've said.
And yes, and I'm urging you to say that every day before that, which is greater than R plus 14, is also a deprivation of liberty. The triggering act is contained in Section 14A. That's the filing of the reports. This Court has said that the triggering act is not governed by the 14-day limit. In other words, I'm sorry, by the 45-day limit that's contained in the statute.
That's Gagnon, right?
I'm sorry?
Isn't that Gagnon?
Yes.
So that's where I'm having trouble. I mean, Gagnon, you have the reports filed after more than 45 days, but the statute says they shall be filed in 45 days, right?
Correct.
And then you have the petition having to be truncated because it's got less than 15 days, but it's still within the 60 days.
Correct.
And the Court said that's okay.
That's right.
So here we have reports filed.
Because your R plus, because in that hypothetical, the R plus 14, if the all had been filed correctly, plus 14, you would have got to 60 days.
Correct. And to let me
So
try
that,
to combine
so that
both
you
of-
can do R plus 14 or R plus 12, as long as you're within 60 days.
That's correct.
But what you, and you don't have a deprivation of liberty.
That's correct.
What you can't do is have R too far plus 14, that gets you over 60.
If I might offer a slight correction to that, what you can't have is R plus 15, 16, 17, or 18.
No, I understand that. But what I was saying is, Gagnon is because if you took, if you, in the sense of slicing off appropriately from the 14, because R can extend out a
Correct.
fair length of time.
That's correct, Your Honor. I mean, in theory, a qualified examiner who is not an employee of the Commonwealth could file a report 65, 70, 80, 100 days from the date of commitment. And if all you looked at was Section 14, then the Commonwealth would still have 14 days to file its petition. If you look at Section 13 as interpreted by this Court, under those circumstances, the petition...
Commonwealth loses because you, so the Commonwealth has to tell its experts, I've got 14, you have to do this within a period of time such that everything can be wrapped up within 60. So while in theory you can take 61, in fact, as a practical matter, you can't.
That's correct.
But we didn't go over 60 here. That's why I'm,
Because you went over R plus 14.
Right.
Because it's not greater than.
In other words, my argument becomes that the triggering event is the filing of the reports.
In other words, viewed differently, Mr. Miles, and I'll ask Mr. Townsend the same question. What the legislature is saying is there are serious deprivations of liberty here. Viewed one way, we want to get these people to their liberty as fast as possible. We're going to give you some leeway, the maximum of which is 60, but that's the maximum. Within that, we're setting up a set of procedural things, and we say shall within 14 days. So if you get the report on day 2, you have 2 plus 14, and if the Commonwealth hasn't acted, the person is free to go because it says not more than 60. It doesn't say shall have 60 days to do all of this.
That's
So
my
that
argument.
every day that somebody, after the report has been filed and the Commonwealth isn't acting, they are deprived of their liberty if it is beyond 14. Am I
That's the appellant's
but
argument.
I understand that, but doesn't the statute also say that the report shall be filed within 45 days?
It does, Your Honor.
So that, too, could expand it, right? I mean, in other words, it can't expand it beyond 60 days, but because you've got the 14, then, I mean, if they did it as here, do you see what I mean? I mean, I just
Yes,
don't see why
but what
that doesn't also have the same, you don't make the same argument about that, but Gagnon said you can't.
In my view, Your Honor, I should be able to. Unfortunately, 7 justices have
Right.
said I can't.
So that's
So
why
I
I'm
have to
saying-
go by that.
But given that, why is this different? That's
This
what
is
I'm trying-
different because the 45-day limit governs the actions of the qualified examiners who are not employees of the Commonwealth, are not the government. In this situation, the mandatory statement of the legislature resolving the constitutional tension is that the Commonwealth must file, shall file, within 14 days of the date of filing of the...
It simply means that if, for example, the hypothetical, and I realize it's only a hypothetical, the examiner takes a look at this and says, this person absolutely shouldn't be held. And so on day 2, files a report that says should no longer be incarcerated. That does not give the Commonwealth 58 days when the statute says it shall do it within 14. It has 14 days, and so you've got 2 plus 14 is 16, and from your point of view, from 16 to 60 is an unlawful deprivation of liberty.
That's correct. And if I may go back to the question, Justice Cordy.
If, on the other hand, the expert is taking his or her time, maybe because the case is complicated, maybe because their schedule is busy. Commonwealth, the legislature probably realized they couldn't ask experts to produce reports in 2 days, gave them 45 days. But if the 45 days was taking away from what the Commonwealth would already have had, made no difference.
I'm sorry, Your Honor.
In the Gagnon case, it made no difference
That's
because
correct.
the combination fell within.
Right. As long as the combination fell within the 60-day period, everything was fine because the triggering event, the filing of the reports, didn't occur within the 45 days. But once the triggering event occurs, then the Commonwealth has 14 days. Once the 14 days expires, liberty has been deprived. And I would submit that the deprivation of liberty in and of itself is a substantial prejudice to the appellant.
But why isn't the 45-day period for the qualified examiner's reports triggered by the judge's order appointing the qualified examiners? Each triggering event seems to have some fallibility, or at least that one we said has some fallibility, so long as it fell within the 60 days.
Right, and I understand the quandary. The only explanation I have to harmonize that is that the action of the government, of agents of the government, is taken, has to be taken within 14 days of a triggering event, which is the reports of the qualified examiners.
But aren't the qualified examiners agents of the government?
No, I don't believe the statute says that. As a matter of fact, I believe that the statute would indicate that they're supposed to be independent and neutral experts who are employed by a private entity called FHS. And I understand this is not in the record, but the way I look at this scheme is that these are the equivalent of court-appointed experts.
But except that, I mean, the government so the government hires these independent experts, and it imposes a deadline on them. Why don't they have to live up to the same deadline as they're still agents of the government?
I don't believe that's accurate, Your Honor. I mean, the qualified examiners are not necessarily employees of any governmental agency. They can be employees of a private agency given the responsibility of administering treatment at the treatment center. They can be private individuals in private practice. The only interaction between the government and the qualified examiners is that under the statute, the DOC has to designate them as qualified examiners. Once that occurs, they become qualified examiners subject to appointment in these cases. They are not, for example, equivalent to the retained experts that the district attorney's office will use on probable cause determinations. They are in a different category, and I would submit that at least the Commonwealth always maintains the qualified examiners are not employees of the government or agents of the Commonwealth. Now, if I may comment just briefly on a couple of the arguments that were raised in my brother's brief, I would point out at page 9 and page 10, I would submit that the Commonwealth is inconsistent with itself. The Commonwealth maintains that somehow if the court limits the Commonwealth to a 14-day period after the triggering event, which is the filing of the reports, occurs, that the Commonwealth will react by automatically petitioning in every case and not exercising the measured judgment which apparently the statute calls for. And then on page 10 of its brief, the Commonwealth says, of course, we have to recognize that assistant district attorneys and district attorneys are ministers of justice and will not fall into that trap. I would submit that that argument as a whole is simply spurious. The legislature has mandated a particular time frame for the actions in this case. In this case, the Commonwealth failed to comply with that mandate. The Commonwealth, therefore, loses the power either jurisdictionally or as a statute of limitations to petition for the commitment of the appellant. I would submit that this follows a statutory scheme that the legislature has used before. If one looks at statutes of limitation that also are accompanied by statutes of repose, it becomes clear that the legislature can set both a flexible boundary, which starts at an uncertain time, for example, upon discovery of an injury, but cap the amount of time that someone has to bring an action to 6 years in the case of real estate improvements, or 9 years in the case of medical malpractice, something that has been done before in civil cases. Thank you very much.
Thank you, Mr. Miles. Mr. Townsend?
May it please the Court, Thomas Townsend for the Commonwealth.
At the worst, a hyper-technical violation that should not oust the Superior Court of Jurisdiction?
I'm sorry, I missed the first part of your question, Your Honor.
Don't we at worst have a hyper-technical violation that should not oust the Superior Court of Jurisdiction?
Correct. I think this is actually the flip side of Gagnon.
But what if, in this case, what if the qualified examiners had gotten their reports in within 10 days of the court's order? Can the Commonwealth sit on its hands for another 49 days?
I
50 days?
foresaw that hypothetical and addressed it in my brief. I say no for two reasons. Number one, I don't think in practice that's could happen. I think the qualified examiners need more than 10 days at a minimum to get the reports from the court, to get the reports
But
from the
just answer
district
the
attorney.
hypothetical, Mr. Townsend. I mean, that's the question.
Hypothetically, yes. But also the second part is
Practically, no, because
practically no.
the only time it would really get, at least in my opinion, to a constitutional violation or egregious statutory violation would be if those QEs said he's not an SDP. If they say he's an SDP, seems to me, no court, and he's very dangerous, so forth, no court's going to release him.
Right. My
Is there
second
anything in the record that, I mean, are the examiner reports in the record?
I believe they are in the record. They were entered at the probable cause.
Was there any disagreement amongst them about
The two
as to-
qualified examiners found him to be sexually dangerous. And the second point I would make that would go against the hypothetical is I don't think any prosecutor, in accordance with his or her duty, would sit on an SDP
Why
petition.
doesn't the prosecutor obey the statute that says shall do it in 14 days?
It's a paperwork backlog or something, or an oversight.
And I believe in this case it was an oversight.
But, Mr. Townsend, you say it's an oversight, and you say they wouldn't sit on their hands. I mean, the legislation is very clear, shall do it within 14 days. They didn't say everything has to be wrapped up in 60 days. Had the legislature done that, I would have no problem.
The legislature was equally clear in 13A in saying the qualified examiner shall file within 45 days.
But we concluded that that was really for the benefit not of the respondent or the defendant, but for the benefit of the Commonwealth, to ensure that the Commonwealth got their full 14 days prior to the expiration of the commitment.
Correct.
So to the extent that the prejudice of something that went beyond 45 days was to the Commonwealth.
Correct. I think that's still here.
Do you?
Contrary to what
Why?
my brother says.
You got 14 plus, 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 plus.
Well, I think this Court's precedent is useful in this instance. I don't think R plus 14 is the standard. If that were the
It's
standard,
it's just what the language of the statute says.
I understand, but if you're looking at the intent of the statute,
But I'm looking at the language of the statute. I don't get to look at the intent of the statute until I look at the language of the
well,
statute.
as I said before, the language of the statute is equally clear in 13A. And in Gagnon, if that were a preclusive shall, then Commonwealth would have lost that case. Equally, in this Court's most recent case in Sargent, that was a 14A violation as well. In that case, the Commonwealth filed a day early before the qualified examiners filed their reports. That fell outside the 14-day window. That was a violation. But
Well,
again,
we-
What about Commonwealth
reason.
versus Gross? Didn't we say failure to file a petition within 14 days was fatal?
that was in the context of Commonwealth never filing a petition. I'm glad Your Honor brought the discussion back to Gross, because in Gross, the qualified examiners filed their reports on the 45th day in accordance with the statute. Under the 14A, the Commonwealth would then be required to file by the 59th day. Commonwealth never filed a petition for trial in that case. This Court, in its opinion, found the harm occurring not upon the expiration of day 59, which would be R plus 14, but upon expiration of day 60, which would implicate the defendant's liberty interest. This Court in Gross went to great lengths recounting the case law going back to Gagnon, including Para, and said that the overall scheme of the legislature is a 60-day period in which the defendant is confined.
That is correct, Mr. Townsend, but if you take just the 60 days, then everything else in 13A and 14A we write out of the statute.
Well, arguably, this court wiped that out of the statute in Gagnon.
I don't think it did.
In Gagnon, we actually said, yes, there's been a violation of the statute. And the question was, okay, who was prejudiced? The Commonwealth was prejudiced, not the liberty interests of the defendant. And therefore, dismissal was not an appropriate remedy, obviously.
We did not write it out of the statute.
I agree, and I agree there was a violation of the statute here, as there was a violation of the statute in Gagnon. The question is the remedy. When we look at the remedy, we look at the overall scheme of liberty
If we agree
interest.
with you here, this is the first case. Every other one is different. This is the first. If we were to agree with you here, then this court, for the first time, has written out of the statute the 15-day prior to the expiration of the qualified examiner, and such petition shall be made within 14 days of the filing of the report, is simply written out of the statute. And there is powerful jurisprudence of this court that says we don't do that.
I think what the court in Gagnon did was recognize that the legislature wanted to divvy up time from the 60-day confinement. After probable cause hearing, the defendant is deprived of his liberty for a maximum of 60 days. There's two different commonwealths that have to do something within that 60-day period. There's the qualified examiners, who are considered part of the Commonwealth. This court called them part of the Commonwealth in the Gagnon case. And there's also the district attorney. Now, although they're both represent the Commonwealth, they're different entities. And so the legislature wanted to ensure that each entity had sufficient time to do its job.
And it gave you 14 days.
It gave us 14 days.
It didn't give you 14 plus.
I
It didn't give
understand
you
that.
the opportunity to bargain with the other part of the Commonwealth to say, if you do it in 5 days, that'll give me 54.
Right, and it gave the qualified examiners 45 days. Now, in Gagnon, the qualified examiners violated that portion of 13A. But stepping back and seeing what the remedy should be, there was no
Yeah.
deprivation of liberty.
Exactly. Why should we quibble over this? All right, so let's say the statute's been violated. Fine. Question is there prejudice or harm? Answer, no.
There is no prejudice because under the statute, the defendant, well, the Commonwealth would petition on the 59th day at the maximum because the qualified examiners would
if the
file by
Commonwealth
day
had-
45.
If the Commonwealth had petitioned, as it should have done, within 14 days, then if it hadn't done that, in other words, if we agree with you, there's no remedy for a violation of a statute.
In this case.
Within
In
60
this
days.
case, within this, if
Because
it's done
6
within the 60 days.
This court in Gross adopted Justice Greenberg's point in the appeals court. He said what the statute does, it has a default mechanism. After 60 days, the defendant gets to go free. The Commonwealth has to do its business within 60 days. The defendant doesn't get to go, or if the Commonwealth petitions for trial before then the next stage of trial preparation begins.
On
But
the facts of this case, because it was filed within the 60 days, 2 days late, there's no harm.
there's no harm because even
Isn't
under
that the end of the case?
I believe it is, because under the statute, the legislature foresaw that the Commonwealth would file on the 59th day maximum. Here, the Commonwealth filed on the 59th day. From the defendant's liberty interest point of view, there's no prejudice. Qualified examiners filed 2 days
The
early.
legislature surely did not intend, in the circumstances we have here today, that someone that's been found by 2 qualified examiners to be sexually dangerous is going to be released on these facts, did they?
Well, especially if you look at the purpose of the 14-day mechanism. It's not for the defendant's benefit, it's for the Commonwealth's benefit, so it can give a rigorous reassessment of its petition and decide whether it wants to go forward to trial. That should not bestow on the defendant a dismissal option for its breach. What protects the defendant's liberty interest is the 60-day period. And under Gross, as this Court had adopted Justice Greenberg's point on this, it would lapse and his interest is protected. From the defense point of view, it doesn't matter whether the ball is in the qualified examiner's court or in the prosecutor's court, because it is the Commonwealth who has...
Mr. Townsend, do you think the Commonwealth should be sanctioned in any way? The attorney, the district attorney's office, the associate...
I think that would be a fact-specific inquiry.
No. I mean, it's gone past the 14 days. It's violated a statute. We don't get
It's
to...
not you, is it?
No, it's not me.
No, the person...
I would appreciate
All right,
the
you can
footnote.
talk freely then.
No, but I think...
What do we do with the Commonwealth when the legislature has laid out very very specific demands.
Well, I think the legislature in crafting the 60 days recognized there could be some wiggle
No,
room.
that's to deal with the defendant. Now I'm
Correct.
talking about the Commonwealth. 14 days, I've got to go away, I've got a hearing downtown, I didn't input it, secretly lost it, computer didn't work, dog ate my homework.
Well, Your Honor, respectfully, I don't think prosecutors approach their job with this without
I don't think they
type
do
of chagrin.
either. I don't think they do either. I think there are prosecutors who all across this Commonwealth work nights and weekends so they can meet their statutory mandates. And the question is, when the legislature says shall, we had a case right before us. Legislature says shall, didn't say should, said shall. What do we do with prosecutors who don't obey the directives of a co-equal branch of government?
Well, the greatest deterrent would be to have this case thrown out because it failed to meet the 60-day deadline. And that's built in the statute. That's the deterrent that would ensure.
No, but you're just saying before the deterrent we can play fast and loose. I'm not saying you do. But I'm asking, what should the consequences for the Commonwealth be when it violates a clear command of another branch of government?
I don't think there should be any consequences in this scenario. Under the horrible hypothetical where the Kiwis come back within a week and the Commonwealth sits on it for 50-odd days,
No, I'm not talking
perhaps.
about that. That might have been because nobody anticipated a report would come back within a week, and there was no more malfeasance or willingness to disobey. I mean, we hold all kinds of people accountable if they do not obey the laws of this Commonwealth. It is a law of this Commonwealth that the Commonwealth file within 14 days.
And I agree it was breached in this instance. And as in Gagnon, I don't think there's should be a sanction of dismissal or any other sanction in
That's
this
different.
case.
Or any other sanction?
Or any other sanction, I don't believe. Because from all we know from this record, it was 2 days late.
For
It
all,
was
we know
non-intentional.
from this record, there was a deliberate flaunting.
Right, we don't know. I don't think this court's in any position to levy a sanction, whether it were to instruct a lower court to inquire further. That's up to this court. But I think this is comparable to Gagnon. Gagnon actually had an 8-day delay from the qualified examiner's reports, and the Commonwealth acted with great speed in order to file the petition for trial on time. Here is only a 2-day delay, but it did not fall outside the 60-day period, which I think would be the ultimate deterrent for prosecutors to
Well, we've drawn that line. We have drawn that line.
in Gagnon and Para and Gross, and I think this case follows naturally from those prior precedents. And that's the line that's set in stone. And prosecutors have lost petitions for violating the 60-day rule, and that would have happened if the prosecutor in this case had waited two more days. And I would ask that this court affirm the motion judge's denial of the motion to dismiss and reaffirm the Gagnon line of cases.
Thank you, Mr.
Thank you.
Townsend. We'll take a break.